Hi everyone, my name is Rutuja Deshpande and I'm pleased to welcome you all back to today's symposium. Our next panel is on competition issues and it's going to be moderated by Jennifer Sturiel. Jennifer is currently a visiting assistant professor of law at the University of Maryland. And with that, I'll pass the mic to Jennifer.
Thank you. So today on our panel on competition issues, we have with us 4 panelists. We have Carl Shapiro, who is an economist. His expertise includes issues related to antitrust, IP, and innovation. He's a distinguished professor of the Graduate School at the Haas School of Business and the Department of Economics at the University of California at Berkeley. He's also the Trans-America Professor of Business Strategy Emeritus at Berkeley's Haas School of Business. From 2011 to 2012, he served as a member of President Obama's Council of Economic Advisors, and he has served twice as the Deputy Assistant Attorney General for Economics of the Antitrust Division of the Department of Justice, first from 1995 to 96, and then again from 2009 to 2011. Professor Shapiro is the co-author of the critically acclaimed book, Information Rules, A Strategic Guide to the Network Economy. We're also joined by Michael Carrier, who is the distinguished professor at Rutgers Law School, where he specializes in antitrust and IP law. He is the co-author of the leading IP antitrust treatise, IP and Antitrust Law, an analysis of antitrust principles applied to intellectual property law. He's also the author of Innovation for the 21st Century, and as well as the editor of Critical Concepts in Intellectual Property Law Competition. He's written more than 130 book chapters and articles in leading law reviews, has been quoted more than 2,000 times in the media, and has been cited in courts, including the US Supreme Court. Professor Carrier has testified before the FDA, the FTC, the National Academies, the Senate Judiciary Committee, the House Judiciary Committee, and the House Energy and Commerce Committee. He is a past chair of the Executive Committee of the Antitrust and Economic Regulation section of the Association of American Law Schools. In 2020, Professor Carrier served as a policy volunteer on the Biden-Harris campaign, and in 2016, he served on the ABA Antitrust Section's Presidential Transition Task Force. We're also joined by Daniel Hanley. He is the Senior Legal Analyst at the Open Markets Institute. His research focuses on, among other things, the relationship between technology and antitrust law. His work has appeared in Pro Market, Competition Policy International, The American Prospect, and Slate, among other publications. And finally, we are joined by Shubha Ghosh, who is also an economist. He is the Crandall Melvin Professor of Law at Syracuse University, where he is also the director of the Syracuse Intellectual Property Law Institute. Professor Ghosh is the author or co-author of 20 books, including his latest book, Advanced Introduction to Law and Entrepreneurship. Professor Ghosh's research focuses on the development and commercialization of intellectual property as a means of promoting economic and social development. He also has published extensively on issues related to the pharmaceutical industry, copyright protection of standards, and antitrust law, among other things. In addition to his work at Syracuse, Professor Ghosh works through the New York State Science and Technology Law Center, an entity that provides guidance to entrepreneurs, startups, and research institutions. We're going to start our panel by having each of the panelists are going to make a short presentation. If you have questions that you would like to present to the panelists, you can send them through the chat, and we will leave time at the end to address your questions. Our first panelist to speak today is going to be Professor Carl Shapiro. Carl?
Thank you, Jennifer. Hello, everybody. I'd like to just sketch out some of what I see as the basic economic trade-offs that are involved in right to repair, coming at this from an antitrust perspective, but with very much an eye to intellectual property issues. So I think we all understand that the harms associated with a lack of right to repair for the users of, let's talk about durable equipment, are reduced choice, higher prices, less autonomy, more reliance on the manufacturer. So I just summarize it all as an aftermarket monopoly for the manufacturer, which means you're reliant on the manufacturer after you've purchased the product for as long as you hold on to it, if you have no right to repair or if that's greatly restricted. The Supreme Court recognized in 1992 in antitrust law in the Kodak case that this could present, that monopolization of an aftermarket could present an antitrust problem. So let me just start, as an economist will, with the nice, let's say, well-functioning markets example. Suppose you have a competition among equipment suppliers and well-informed buyers, which is to say they're able to evaluate the total cost of ownership of the equipment, and they can compare different choices. This manufacturer might require I use their parts and service. Another manufacturer might have a very open policy towards aftermarket and give me a lot of right to repair. I'm a user, I choose, companies compete, there's well-informed, there's really no, I would say in that case, there's really not a problem to be solved. If consumers really want right to repair, then somebody will come up and supply them with a product with fewer aftermarket restrictions. Okay, but that's the economist's usual, very simple, unrealistic case. So what gets interesting is when we depart from that. So one departure is a change of policy. I thought that's what I was getting, but then the manufacturer tightened things up later. Okay, so that is install-based opportunism. That's what the Kodak case involved, actually, in allegations. And so that can clearly cause a problem in that I cannot get what I was expecting when I bought. The big debate there, I think, is whether contract law or antitrust law should apply there. I think antitrust law should come to bear, but the defenders of the manufacturers say otherwise. So that's install-based opportunism or change of policy. And that's mostly where the courts have gone and said if there's no change of policy, they often don't see an antitrust problem. Okay, so that's one area to go into. The other is poorly informed consumers. Automobiles, we were hearing a lot about it. It's a huge area. Who really knows what the manufacturer's policy, the availability of spare parts will be, what their prices is, what their rules are regarding who they authorize, so on and so forth. So assuming users, buyers of equipment are well informed about the whole life cycle cost and compare manufacturers on that basis is not very realistic a lot of the time. So if you have poorly informed consumers, then competition won't really protect them in the aftermarket because competition among equipment makers does not occur on that basis. Competition among manufacturers could lead to nice low equipment prices because all the manufacturers will say, I'm going to take advantage of my buyers in the aftermarket because they're not even thinking about that when they buy. And so we expect that sort of exploitation in the aftermarket, restrictive policies, but low equipment prices. So that creates its own problems. That's not very efficient. And there's ways to solve that. I think of that often as a consumer protection problem, just like we often have something like energy efficiency standards, so that people don't buy refrigerators unknowingly that are very high energy use, or we might have labeling requirements or disclosure requirements. But there's a bunch of policies for that. But the key thing is if we force, let's say, right to repair, we have to understand that will then probably lead to higher equipment prices. Okay, because the companies are going to compete with low equipment prices in order to get the juicy aftermarket profits. They can control that. If you take away the juicy aftermarket profits, they're not going to compete as much on the equipment price. So that's a fundamental trade-off. And that means there are different winners and losers. If you're a heavy user of the equipment, you really want those cheap parts and service because you're using a lot of it. If you're a light user, you might be better with the lower equipment prices and lack of control in the aftermarket. So pushing for right to repair has differential impact on different users or customers depending on their intensity of usage. I should say all of this applies regardless. We've talked about a lot of mechanisms a company use to control their aftermarkets, intellectual property, contract, tying, et cetera. What I've just said, these trade-offs are fundamental and they apply across all of these methods, these trade-offs and different market conditions where we'll see different impacts of establishing or pushing for a right to repair. The last thing I'd say, and I'll reserve a little time, is the notion of resilience. I think what we're seeing, and we heard about Apple changing their policies, some companies may be realizing that it's not so good if they want to maintain control if they can't deliver. You know, it's fine to charge high prices in the aftermarket, but if the supply chains are broken. So resilience, one of the great things about competition is it does often give greater resilience than monopoly or a few choices. So we may see voluntary movement in that direction to reflect the more resilient benefits to users of giving them more choices. Thanks.
Thank you. Sorry. Thank you, Carl. Next, we're joined by Michael Carrier, who has a proposal for how to address some of these issues using Section 5 of the FTC Act.
Thank you so much, Jennifer. Thank you to the editors of BTLJ for putting on this conference, for publishing these pieces. It seems like these pieces might have an effect, given how timely the issue is. Thank you to Pam Samuelson for the invitation. The right to repair was not something that was on my radar, and now it is, and so I appreciate that. And thank you to Aaron Perzanowski for doing such great work in this before it was such a hot issue. Really exciting stuff. So what I'd like to do is first, really quickly, talk about how the right to repair presents really interesting and important issues. Second, discuss, similar to what Carl said, how antitrust does not seem to be up to the task of dealing with these repair issues. And third, offer a proposal for addressing the competition issues through Section 5 of the FTC Act. So first, there are significant competition issues presented by the right to repair. Let me just mention 3 areas in which we have seen this. So the first is ventilators. There is control over ventilators through service manuals, software, and diagnostic information, which means that if you're in the hospital and you need a ventilator to keep, I don't know, patients alive during the COVID pandemic, you do not have access to that ventilator. That ventilator is pushed offline, you can't use it, and people will die as a result. And so that's one example. The second example is the military. And so there was a comment sent to the FTC by a couple of Marine officers who talked about the software tools and contract that prevent the military from fixing their own equipment during the middle of battle. And they said this has a real effect on the service members, on the defense, and even on the US's ability to win wars. So that seems to be a pretty significant effect as well. And then finally, something we've heard about, farmers. So farmers lack the ability to fix their own products by their nature. Farmers are able to fix products. Once you have software that controls every one of thousands of elements of a tractor, all of a sudden they can't fix it themselves. And the problem is that there are so many different types of restrictions that even if you get an exemption under the DMCA, thank you, Kit, for your great work on this, John Deere will respond the next day with a license that makes everything that you thought you could do impossible. It says you can't reverse engineer and can't do anything else. And so John Deere seems to have market power here. It is supplemented by their control over dealers. You could be in a state where the only dealers around are John Deere dealers. You also don't really have a choice if the other manufacturers have similarly restrictive terms. So at the end of the day, when we think about the ventilator, the military, and the agricultural setting, we see how this is really a problem. So second, if it's a competition problem, why can't antitrust work? And the problem stems from the courts. And so as Carl mentioned, 30 years ago, there was a case called Kodak in the Supreme Court, where the court said it could present an antitrust issue if you have monopoly power in the aftermarket, the market for parts and service. Even if there's a robust competitive primary market, you still could have aftermarket power. The difficulty is that that decision really has been limited. And most of the courts say you have to show a change in policy. Many times there's not going to be a change in policy. And so you don't really see a lot of Kodak claims today. It's too bad because it seems like the aftermarket is a good fit for what's going on with the right to repair. You're just trying to fix your product. And who knows if the initial market is competitive or not, but we don't have Kodak. And so what are we going to do? Again, I think that competition can play a role here. Antitrust is not up to the task. And lo and behold, we do have another tool. That tool is Section 5 of the FTC Act, gives the FTC the power to challenge unfair methods of competition. Section 5 goes beyond antitrust law, and that's clear because if it did not, it would just be redundant to antitrust. But Section 5 should have some limits because if it means nothing more than what 3 out of 5 FTC commissioners believe at any particular time, then that doesn't give a lot of guidance to businesses. Unfair really can be all encompassing. And so what can we do? And so one possibility is what commentators Susan Creighton and Thomas Kratmaker have called the gap-filling rationale. In other words, if you have an antitrust claim, but one element of it is missing, then you can fill that gap. And so they offer the example of the invitation to collude. So if you have an invitation to collude, then you don't have Section 1 of the Sherman Act because there's no agreement. You don't have Section 2 of the Sherman Act because there's no monopoly, but it seems like something that we should punish under competition law. And so I would take that rationale and apply it to the determination of market power in aftermarkets. And the primary reason is that we're in a far different place than we were 30 years ago. 30 years ago, the court could look at parts and service. A customer could know what the parts and service policy was. It is completely different today. We have software that governs every aspect of all of these functional devices. We have consumers who have no idea, who can't engage in life cycle pricing. And so therefore, I think that there is a role for Section 5 to play. So I would offer my gap filler in one of 5 situations. The first is where multiple manufacturers have restrictive terms. The second is where there is monopoly power at a separate level of the distribution chain. The third is where the users lack knowledge. The fourth is where there are anti-competitive effects that are felt not just by the original buyers, but by later buyers as well. And the fifth is where there are time-sensitive uses. If you think about these 5, these get to the point that the consumer functionally does not have a choice. If multiple manufacturers have the same policies, you can't go to another one. If you have John Deere owning all the repair shops in Montana, then there's no choice there. If you have timing issues where your lives are at stake with ventilators in the military, your livelihood is at stake. If you can't harvest a crop in the few days in which the weather is cooperating, then that tells you something as well. And finally, why focus on a change in policy when the consumer has no idea in the first place? And so I think that the addition on market power is supplemented by the extreme anti-competitive effects here. Again, this affects lives and livelihoods, and also by the questionable pro-competitive justification. So let me just mention the 2 main ones that are cited and then raise some questions about them. So if you ask the manufacturers, they say we have to do it for safety reasons and also for IP, in particular copyright reasons. In terms of safety, the FTC had an exhaustive process here. They had a workshop, they had a call for empirical proposals, they had all of these comments. And at the end of the day, they said there is no safety issue here, that the manufacturers had every ability in the world to introduce all this information and they didn't do so. So I think that tells us something. It's consistent with what the FDA found when the FDA looked at OEMs and compared the original equipment manufacturers and compared it to what third-party servicing organizations did. It found 0 difference in terms of safety and concluded that these independent organizations served a valuable role for the healthcare system. And so there's no effect there. In terms of agriculture, these parts had to be shared in Europe, and we don't have safety events in Europe. So at the end of the day, safety is going to be something that the manufacturers are always going to talk about, but the absence of empirical data is telling. Finally, in terms of IP, and let me focus on copyright because that seems to be where most of the action is. I'd say, first of all, there's no such thing in any reasonable assessment of immunity from the antitrust laws. The Supreme Court and FTC v. activists, as Josh told us earlier today, made clear that antitrust still has a role to play even within the scope of the patent, that you can't determine the competition assessment of a situation just by looking at the scope of the patent. Antitrust has a role to play as well. The court traced that back going decades, back to the 1940s and 50s. So clearly there should be a role for antitrust to play. There's no such thing as IP immunity. In addition, when you get to Section 5, I would say you should have a little more leeway, a chance to think about policy. When we consider the innovation access trade-off, here I think we're on the access side of the line because we're trying to access our goods. When we think about the nature of innovation, what typically gets all the attention is that initial generation of innovation based on the patent or copyright, but there's also a lot of user innovation going on here. There's, as Pam tells us, the freedom to tinker that's going on as well, and that's an essential part of the innovation process as well. You have the doctrine that shows limits to copyright. We have the first sale doctrine, we have Section 117, as Kit mentioned before, and we have the DMCA with exemptions and also with intentions of the drafters of the legislation that nowhere said software in functional devices is the goal. No, what they said is we want to protect, quote, the movies, music, software, and literary works that are the fruit of American creative genius. And in fact, they created an exception for interoperability. So at the end of the day, if we can consider policy just a bit, this IP is not about innovation, it's just about blocking access. And so if I can step back to my conclusion, there are some really questionable pro-competitive justifications here. There are severe anti-competitive effects like we don't usually see in antitrust law with lives and livelihoods at stake. We have antitrust not up to the task, given how Kodak has been restricted, and we have a real competition problem with the right to repair. And so that's why I think Section 5 can play a role here. Thanks so much.
Thanks, Mike. Next, we're going to hear from Daniel Hanley. So Daniel, I'm going to let you take it away.
Thanks so much, and thanks everyone. This conference has been really great, and it's really an honor to be invited and be here with such a great panel. And the entire event in general has been such a pleasure so far. Really looking forward to listening to the rest of it. So I want to talk about the importance of repair and really pull up a little bit in terms of where antitrust has a role to play in the right to repair movement. So, firms use a variety of tactics to obtain business from consumers, lowering prices, developing high quality products, et cetera. And these practices are ultimately shaped by the state and the law, and which ultimately determines what methods of competition are fair and should be incentivized and which are not. And similar to how a business can obtain customers, how businesses design products, in my opinion, is itself a method of competition, and one that antitrust law is particularly apt at being applied to. So I don't want to presume that anyone knows a lot about antitrust law. I know its recent application to right to repair is quite new, at least being discussed widely. So the antitrust laws, there's three primary ones: the Sherman Act, which prohibits general restraints of trade and monopolization tactics; the Clayton Act, which prohibits exclusive deals times and also limits on mergers. And then there's the Federal Trade Commission Act, which Michael did a great overview of, which prohibits unfair or deceptive acts or practices and unfair methods of competition. And generally, when you look at those in their totality, they're really saying, okay, how can businesses compete? What is conduct that we want to incentivize? What is conduct that we want to prohibit? And really, if you just think about that in general, how products are designed has an essential role to play in how firms compete, which thus means that the antitrust laws have a vital role to apply to both facilitate repair and its role in product design. And that's one of the things I think is an underappreciated reason of the application of the antitrust laws to repair, is that it's clearly evident that how a product is designed radically affects a firm's capability to unfairly expand, entrench, and perpetuate their market power. Indeed, there are some companies, as former panelists have said, where the design of the product itself is the primary means for which how they maintain, expand, and entrench their market power. Think the design of tractors and combines and ventilators. But not just from the product standpoint, this also affects consumers as well, the relationship that the consumer has with the manufacturer. And you can think of how a product is designed can lead to undesired, continuous, and repeated transactions with the manufacturer. And the most common one, or I think the one that's most easily understood, is the need to go to an exclusive provider for repair services. One of the things I find fascinating about the recent application, or the recent discussion, enhanced discussion of antitrust 2 right to repair, is that it's really one of the latest developments among many that the public is really thinking about, and how to structure and limit firm conduct and how products are designed. And indeed, that the antitrust laws is just one area of law that has a play into this. And in fact, we're really trying to, I think one of the primary roles here of this panel and wider discussions about antitrust and right to repair is where does antitrust have a role to play in being harmonized with these other areas of law that all intertwine with right to repair. The biggest one that's been discussed repeatedly in this conference so far is the intellectual property laws. But if you think about all these areas, they really all structure and limit how products are designed, and there are also other limitations. What materials are used, warnings that need to be included, and that are sort of governed by consumer protection and product liability. So they all really work together in shaping both business conduct and product design. And indeed, even areas like patent law and other IP protections, none of these are really absolute. They're all qualified, and as Michael aptly described, exemptions and exclusions from the antitrust laws are narrow, and they often need to be clearly explicit. So for me, it's the sort of advocacy role that I play is that antitrust law has a very important role to play here. One of the things I just want to take a minute on, I think, is an under discussed reason of why applying antitrust to the right to repair movement is so important, is that it's not just about firm conduct and rivalry. It's actually one of the important aspects of it is to make repair, and indeed in the design of products, an essential and predominant characteristic of firm rivalry, to actually make this facet of competition more prominent, more of an essential role. And why would we want to do that? Well, in one thing, it's very clear that restricted product design is very lucrative. It's well documented that firms make hundreds of millions, if not billions of dollars, in some cases 10 to 20% of their profits from repair services. And indeed, I would argue that our current environment, which is in part a result of lackluster enforcement, actually incentivizes this sort of race to the bottom to create the most restrictive products, to create products where manufacturers and other companies trap consumers, trap dependent firms to exclusively work with them to get their repair services, to create increased transactions with them, to create pricing control, and actually is also which would decrease innovation. I mean, it's a lot harder to compete when you have to open up your product. So indeed, antitrust law can promote innovation in that respect. But the application of antitrust laws also has another important role, again, beyond firm rivalry and competition, is that it actually can facilitate real product ownership, giving people the sense of ownership over the products that they buy and they already believe that they own, and they later find out that they kind of don't when they need to go to an exclusive repair place, or they can't buy a product that a repair part that they need. Antitrust law has a role to play with, being applied in this manner to limit waste, to lessen deception, to help inform consumers that the product that they're buying is repairable or can be repaired. It also can strengthen our supply chains by opening up how many firms are available to both supply parts and conduct the repairs. And all of these problems are actually exacerbated by monopoly, less suppliers, less producers, undue bargaining power over these parties. And I just want to quickly wrap up. I don't want to extend too far over my allotted 10 minutes, but there are just a couple of ways in which antitrust law can help open repair. It's prohibiting tying, which is when a person buys a product, they shouldn't necessarily be required to get the service of repair, limiting exclusive deals to open up who can make products, who can supply certain parts. And all of these, again, have implications of, again, applying antitrust law rather has implications of helping lower prices for consumers, providing alternative outlets, limiting waste, prohibiting or making it or deeply disincentivizing product obsolescence and giving a sense of true ownership of products for consumers. And in general, and I think I'll just end with this point, that in general, opening up repair indeed facilitates a kind of behavior of, the idea of tinkering, the idea of spawning innovation by being able to take apart something and look at its internal operations and develop your own product. So indeed, that antitrust law in this way, by opening up repair, can spur lots of innovation and better products and services. So thank you so much.
Thank you, Daniel. Finally, we have for the opening remarks, we have Shubha Ghosh. Shubha, you want to take it away for us?
Yeah, thank you, Jennifer, and thanks for all my co-panelists and for the organizers of the conference. This is 2 years that I've been waiting for with anticipation, so I'm glad this finally happened. I'm going to talk about the continuing right to repair, and I want to explore a little bit about the intellectual property backgrounds that can affect our understanding of the various competition policies that we've talked about, and I think these are important to understand. So my basic thesis is that, let's see why this is happening. Okay, my basic thesis is to talk about the right of repair being grounded in intellectual property's exhaustion doctrine, which is an area I've done some writing on. And I think this is important to spell out for a number of reasons. One of the reasons is that I think the original version of this talked about right of repair under attack. I think this was the title in the 2020 version of the conference. And now we're talking about emerging right to repair. But I think it's important to recognize that the right to repair is more than a statutory right. It does have common law roots. And especially when we look at intellectual property law. And it's good as we develop these statutes and as courts then end up interpreting the statutes, as well as looking at antitrust enforcement, to recognize these important roots to the right to repair. It's also important to develop this connection to the exhaustion doctrine because of the intellectual property, antitrust, intellectual property competition law interface. As Michael pointed out, there is no immunity, but there is some question about whether scope of the patent doctrine still exists or not. I tend to think that Octavius probably got rid of it, but I think that there were dissenters in that case, and they may come back to haunt us. And there are also concerns about the intellectual property licensing guidelines, the role of copyright in intellectual antitrust, and so forth. So understanding a little bit about the exhaustion background, I think is important to develop a more effective competition policy. And so with that, I want to talk about three aspects of exhaustion as it relates to the right to repair. The first is to recognize that whenever we think about exhaustion within intellectual property, we tend to equate it with the first sale doctrine that exists, across all the different areas of intellectual property, whether we're talking about patent, copyright, trademark, or even trade secret. But exhaustion applies to use as well as resale. And so just very briefly going back into the doctrinal abyss or the doctrinal morass a little bit, the Bowman case that the Supreme Court decided, in 2013 or so, did talk about exhaustion not applying to making a new instantiation of a patented product. But we have the Quanta versus the LG Electronics case, which is a very interesting antitrust/exhaustion case, where the court does talk about exhaustion applying to the use of a patented product or a reuse of a patented product. And the right to repair notion as part of that use or that reuse gets established in the Supreme Court case of Wilson versus Simpson, which then gets rediscussed again in Arrow 1 and Arrow 2, where the notion of right to repair comes up as allowing consumers to replace the unpatented components of a patented product, which gets us all into the spare parts issues and other types of repairs issues that we've talked about. And so the basic idea here is that just because there's a patent on the product as a whole doesn't mean that you can't go after the unpatented components and be able to repair them or even replace them in certain situations. The problem that arises is, of course, as Josh and I think has come up in a number of places, is regarding design patents and the way in which ornamental protection sometimes is used to block the right to repair. We saw that in the auto body case that Josh refers to. But there is an exhaustion notion that would apply there, which I don't think has been explored enough. But the notion of exhaustion does cover and throughout intellectual property, and certainly would come up in the area of design patent, and is worth developing and exploring and understanding in some detail. Now, with respect to the other areas of intellectual property, for example, in copyright, we have the first sale doctrine that's statutory and recognizes exhaustion. But we also have, as is pointed out, Section 117, which again is addressing some aspects of the right to repair. And I won't repeat what was been said earlier, but I do want to emphasize again the role of fair use as also covering some aspects of the right to repair, especially in the promotion of interoperability. And again, copyright would arise in terms of exhaustion repair issues. Trade secrets are interesting, partly because the nature of trade secret misappropriation is very different than copyright and patents. We don't necessarily see a express exhaustion doctrine, but an exhaustion does figure into trade secrets, especially when we think about the defense of reverse engineering. In order to reverse engineer a product that contains trade secrets, there is a notion of being able to buy or purchase that product and be able to tinker with it, take it apart, experiment upon it as well. So even though the relationship between exhaustion and trade secrets is a bit more complicated, it still is integral to understanding at least reverse engineering within trade secret law. So this is talking a bit about how exhaustion can apply to reuse. It's also important to recognize that exhaustion, like antitrust, has roots in the common law rules against restraint of trade. We saw that in the Kirstang and in the Lexmark case with the repeated quotes to Lord Cook's treatise talking about restraints on alienation and the importance of preventing those. But exhaustion comes up again. We talked about this in the context of aftermarkets. Why we have this focus of aftermarkets is recognizing that just like with exhaustion, trying to promote aftermarkets, things like the antitrust protection for monopolistic practices in aftermarkets is very important to keep in mind. So I don't think anybody has mentioned yet, but this may come up in Q&A, the 1956 IBM Consent Decree that does have an extensive paragraph that required IBM as part of that consent decree to allow for parts and repair on its machines, on its hardware. And we've already referenced the Kodak case and also the tension that arises between Kodak and subsequent cases such as the Xerox case in the Federal Circuit. I think going back to some of these common law roots about restraint of trade can be helpful in terms of developing the right to repair and understanding how it is deeply connected to competition policy. I think one of the key issues too that's very important in understanding right to repair as a species of exhaustion is that under the exhaustion doctrine, at least as it's developing in current law, the right to repair cannot be limited by contract. This is an issue that touches upon questions about preemption. I know a number of people in the audience may have issues about that, but I think this goes beyond preemption. The Supreme Court's decisions in Quanta and Lexmark reject what's known as the implied license theory of exhaustion, and do come closer to recognizing exhaustion, and then I would argue right to repair as a species of exhaustion, as more of a right that that consumers have within the sphere of intellectual property. And once we recognize that there are limits to how far contract can go, the basic idea that as exhaustion turns on intellectual property right into a contract right, then antitrust principles, whether those that exist in traditional antitrust or, as Michael has pointed out, under Section 5 of the FTCA, and can come into bear in order to deal with these as contractual restrictions. And I want to emphasize, one of the issues that comes up with the first sale doctrine is the sale versus license issue. But that would not be a concern, I think, under right to repair, whether that restriction comes up in a license or in a contract. Would not matter as much or at all in the context of right to repair as it does in the first sale, especially in light of the 1995 and current revisions to the IP licensing guidelines, which would subject these types of restrictions to at least a rule of reason, if not more, analysis. Now, just to conclude, a challenging question is technology protection that blocks repair. And so we've talked a bit about this with respect to the DMCA. With respect to exhaustion, the operative term is that digital exhaustion is a work in progress. A number of scholars have written on this. European courts and US courts are still struggling with this. And I think this may be, depending upon where digital exhaustion goes, one of the harder issues to deal with respect to the right to repair. But I don't think it's insurmountable. I think we recognize, and I think Aaron has written about this, especially in his excellent book, about how digital exhaustion has to be developed, and there are roots within exhaustion law that tries to deal with that. And one example of this would be the Federal Circuit's decision in the Chamberlain case, which may offer some sort of a pathway for limits on technology protection measures blocking repair. If we think about a doctrine of DMCA misuse that may be developing in that and other cases. So those are my basic points about recognizing the importance of exhaustion doctrine in terms of our debates about right to repair as we develop competition policy and really frame right to repair within competition policy, whether in economic terms or in legal terms, or as I've tried to do here, in the intersection of those two. So I think Jennifer wanted to have a conversation, and I'm looking forward to that conversation. So I'll just end my comments there. So thank you.
Thank you, Shuba. I think that Carl was going to make some response remarks first.
Yeah, thanks. Just a few minutes. So first, Michael, in terms of Michael Carrier, I agree that FTC Section 5 is a good vehicle, but it's very unclear how far that can take the FTC given the court. So it's a good idea. We'll see. Generally about antitrust analysis, I think the analysis of any given practice depends heavily on the tactic used and the business conditions that are used to control aftermarket. So this is going to become a nuanced analysis. And here I would make some real distinctions. So I would say product design, maybe in contrast to what Daniel said, I think that's a very difficult area for antitrust to touch. The courts do not like to get into product design decisions, so I would not be optimistic there. Exhaustion is, obviously limits what the firm could do, but it's not going to help with spare parts, probably, I think. They don't have to sell a licensed spare parts. So it's going to depend practice by practice. I think tying, there's a lot of power and potential power to tying in antitrust. Basically, are you tying the equipment to service or spare parts, arguably a separate market, a separate thing with separate demand, which is one of the tests under tying law. So, and I don't love tying law, and I worry about it going too far sometimes, but it's a potentially very powerful vehicle here. And then last, on innovation, we all want innovation. I think it's got to be right that if you have more of a right to repair or aftermarket competition, you're going to get people come up with different ways of repairing things. They're going to tinker, they're going to fiddle. This is how innovation happens. So in terms of the service and parts and the aftermarket activities, opening things up, I would think would be good to innovation. The counter argument by the manufacturers is always, well, we need, besides safety and whatnot, is we need to get all this money. We need this return from the things we created, so we'll make the next generation of equipment. And I'm sort of skeptical about that, but as an economist, I'm pretty open to the idea that it might be good for an equipment manufacturer to be able to essentially price discriminate, meter, charge more for the users who use the equipment more. Now, via car vehicle, they can charge more by people who use it more by having spare parts marked up when you need more spare parts if you drive more. They also could meter potentially, given and think of all this other sophisticated equipment, simply by having something on the machine, tracks it, how much it's used, how far it's driven, and you got to pay them. Now, I think a lot of people here would hate that, but some, it might be good for some users. You know, you get more discrimination, you get differential pricing, and that could help promote innovation by giving this greater return to the manufacturer. And I don't have a moral objection to that, but I think some people would sort of hate the idea they have to pay the car company or the medical equipment supplier every time they take an image with the diagnostic equipment. Yeah, I think it's worth considering what we think of that type of metering, which is what often the companies are trying to do in these by controlling the aftermarket. So we need to use all these tools together. Antitrust, Michael, I didn't really like your antitrust is not up to the job. I'd rather say we need to work to make it stronger, but it can only do so much, and IP is a big part of it, and that's why I want to keep listening to how that works. Thanks.
So we have some questions from the audience, but before I segue into those questions, I just wanted to ask a clarifying question for everyone's benefit. Both Carl and Mike mentioned life cycle pricing. Carl, Mike, I wondered if you might be able to talk a little bit about what life cycle pricing exactly is for those individuals who don't know what it is and what its role in competition is. Carl, you also alluded to it a little bit when you started talking about metering. Hard word for me to say.
Well, let me go first and then Michael, please. So what I mean by what is meant by life cycle pricing, another term would be total cost of ownership, would be when somebody buys a piece of equipment, they're comparing different manufacturers, but the customer says, well, what will this cost me over the entire lifetime that I'm going to own it, which is going to be the outlay initially for the equipment, and whatever I'm going to have to spend over time for upgrades, repair, spare parts, and you do that whole evaluation. And if that's what it means to do that, and you need a well-informed consumer, it's pretty demanding in a lot of cases. And we have a very different situation if that's working, often for sophisticated business customers, less likely for consumers, but that's what's meant by the term.
Yeah, I, of course, completely agree with Carl. That's what it is. And I think today, we're not really able to do it given that consumers are not able to get all this information. And so I think that's a real problem.
Thank you. Okay. So one of the questions we've had from our audience is the relationship between right to repair and interoperability. To someone, it says, does the product repair discussion equally apply to product interoperability at the legal level? But I think that it might just be easier if we just try to describe what is the relationship between right to repair and interoperability.
Well, people are pausing, so I'll jump in. In the cases I've been involved, if a repair person needs to access the diagnostic software on the machine to figure out what's going on, what spare parts it needs, how to fix it, they need to interoperate with the machine in that sense, and they can be locked out by the manufacturer. So at least that's what I have in mind by the ability of a third party to interoperate, to access the information to provide aftermarket service or spare parts as well. So that can be a major technical lockout that's a problem.
I think of interoperability traditionally as been between products. So you think about cases, from the copyright perspective, fair use, the Connectix case, working across different gaming platforms, whether it's going from some sort of a PlayStation or a gaming station to a desktop or other type of device. So So by analogy, I'm thinking of right to repair as going from a parts market or a product market to a service market. And so being able to have that type of compatibility, if you're on the service side of a market with the product side of the market, and so that the product side doesn't lock out the service side, much like any copyright in one platform for gaming doesn't operate or block out developments in other platforms or other mechanisms for gaming. So when I use it, I meant it in that type of analogy, and the fair use cases in copyright law that allow for that interoperability may offer a way to frame how we think about right to repair as a underlying policy in thinking about copyright restrictions on those aftermarkets. If that's making sense. I might have just said lots of different things there, but I hope that's the analogy I meant.
Yeah, and I agree. And I'd also say that interoperability is a subset of right to repair. So even if you have interoperability, incredibly important, of course, you might not fully have a right to repair if there are other restrictions that are preventing you from repairing the product, like a license or a physical design mechanism or something like that.
Yeah, I don't like subsets. I've been trying to get away from Bertrand Russell and all that. But anyway, I would view it in just not to contradict Michael, but as a type of reuse or repurposing, which is what a lot of these fair use cases, especially Google versus Oracle, and we're seeing that with the Warhol case, is largely about is the broader. So it's if you like subsets, it's more of a they're both subsets of these problems of reuse and repurposing. I would frame it differently, but that's not. I don't think that's contradicting anything Michael said.
So we have another question about you may or may not know. I am not familiar with the terms. There are ways to repair the electronic systems and tractors now that respect right to repair, like JOLTIS diagnostic tool. What do you think about it? I don't know anything about that, so I'm hopeful that you all know what the JOLTIS diagnostic tool is. No.
I don't. I've talked to tractor resellers actually in contact in the past, but anyway, that's another issue. So I don't know that specific one. I would imagine if I were to just try to take a stab in the dark, that 117 might apply. But again, I'd be looking into, to quote Kyle's language from the previous session, addressing one abyss with another abyss, I guess. But I'm not specific, but I'd be glad to learn more about that system. So.
Well, look, I don't know the details, but if somebody figures out a way to get to I'll say John Deere tractor without violating their copyright or the rules, whatever, that's obviously the users are going to be very interested in that, to give them opportunities. It can become a cat and mouse game. I don't know, maybe the next generation John Deere will design something so that's harder, or they'll put in more blocks. So my sense is that sort of tactic could be quite useful, but it may not give ongoing protection for owners if we don't have the right legal regime in place.
I also would like to just make the observation that when we're talking about these sort of competition issues, there seems to be broadly speaking, two issues. One is the repair by the individual tinkerer, right, which is different than a producer in the aftermarket, right? And so I think it's helpful to try to disaggregate those two. So we might think that we have different solutions for the individual tinkerer, maybe even analogous to like a fair use in terms of competition purposes, versus what the competition issues are for firms competing in the aftermarket. I don't know if you all have thoughts about that.
Yeah, I think that's interesting. And I think it taps into the fact that this is a really hot issue because it just strikes right to the core of something that's wrong. So you can go back to the Kodak case and say these independent servicing organizations were heard, and okay, that's fine, and competitors are heard all the time. But here you have farmers that by definition know how to fix their tractors and have for decades. And all of a sudden a change has been made. And so now their big expensive piece of equipment sits there, is on lockdown, and you can't do anything at all with it. And so I just think there's a difference. And I think that might explain why this is such a hot button issue now.
Let me push back against Michael a little bit, which I hate to do because he's so good, but I would be wary of making a big distinction between the customer, the owner of the equipment, repairing their own equipment, and they're getting a third party to do so, because often in many markets, smaller users don't have the capabilities. So if you only enable the direct customer owner to do things, you're going to actually be making it more difficult for them. You know, even in airlines, the larger airlines do a lot of their own repair and maintenance of their aircraft. Smaller ones don't. Okay, so I would be a little bit wary of that. I'd think of it more of the owner has the right to either do it themselves or get somebody to do it if they don't know how. And these days, a lot of equipment is pretty sophisticated for a good reason, not a nefarious reason. And not that many customers, owners again, can really do it. So I would like the right to be broader, not just taking care of your own stuff.
Yeah, I think from an economic standpoint, yeah, I think it's just one market. Either you do it yourself or you contract out to hire somebody to do it. But it's that broader market is the thing that's being affected by impediments on this right to repair, however exercised, whether through self-help or through contract. I guess when you start getting into the weeds about the different legal regimes, then this market analysis can be more nuanced in that way. I mean, whether you're talking about fair use, I mean, that's typically, I guess a fair use copyright case would be brought by somebody who tried to either repair it themselves or they couldn't. I mean, to go back to the software repair example from Robert in the first panel. But I guess it could also be raised by service repair people, but they may have 117 as an additional, the diagnostic aspects of 117. So I mean, I think when you get into the weeds, the legal regimes can become important in terms of how you understand the markets or the submarkets.
Excuse me. So we have another question of, do countries need to amend the World Intellectual Property Organization treaties in order to ensure absolute rights to repair?
If they mean WTO, this is one of the reasons why I like grounding right to repair in exhaustion, because the WTO's, the TRIPS agreement, gives nation states leeway under the Exhaustion Doctrine, at least depending on how you read Article 6. So I would say you don't need to amend at least the TRIPS agreement to do that, though you might get into problems with some of the limitations and exceptions. But yeah, I think having maybe some recognition of the right to repair in the treaties would be a good idea, so we don't have to play these kind of these types of games.
And another question is, what would ideal legislation in the United States look like? Does Congress need to both change Section 1201 of the copyright law and give the FTC and the state attorneys general, enforcement authority?
I think the more tools we have, the better. And so I focused on Section 5, and I agree with Carl, I'm being a little harsh on the courts, and there's no reason why the courts can't recognize an aftermarket claim. It's just that the trend is going against it. But let's have Section 5 antitrust law. Let's fix or get rid of the DMCA. Let's have legislation on the state level. Let's have legislation on the federal level. There are so many ways to tackle the issue. And one of the reasons why I'm so excited to find this issue probably later than everyone else on the call is because in thinking about the antitrust IP intersection, there are a lot of really hard issues. And the hardest issue is, what do you do when you have a company that legitimately is relying on intellectual property, but also using it to harm competition? And oftentimes there's not a clear answer. One of the reasons why I think some of the answers here are clear is because the anti-competitive effects are extreme and the IP justifications seem to be incredibly weak. And so that's why I think the more tools we have, the better.
We may have more questions that we can get through, but let me try to address as many as possible. There's a long and sad history of connected device makers, for example, Google, Sonos speakers, Jibo, the social robot, suddenly killing off bricking totally functional products simply by disconnecting servers needed for the products to operate. This might follow a corporate bankruptcy or merely a decision to stop supporting the product. Is there any existing federal or state law that would prevent companies from doing this? Should this constitute an unfair or fraudulent business practice?
Let me go first. I mentioned the so-called installed base operatism, where a company basically selling you something. You expect that you have certain rights or repair or interconnection, and then 3 years later they say, no, you don't. Right? We've changed it. We've cut this off. We've changed that. That clearly can harm users. And again, the Supreme Court 30 years ago recognized that as an antitrust problem. The difficulty is, what's a change in policy and what's just adjusting to technological change? We have 5 new versions and we're no longer supporting version 1.0 or in version 6.0 and you have to upgrade or this. You can't tell companies, particularly in technologically changing markets, they never can change things or they have to always support everything. So it gets really in the weeds, it gets tricky and the courts have trouble with that. I don't know of a good answer, but I'm sure Michael does.
I like that. I liked that pass off.
So I don't have a great answer either. Product design is a really hard issue. It's hard for courts to deal with this. There should be plenty of deference to innovation, and in the courts, the only cases that fine for the plaintiff are the ones where it really is a pretext or a sham. And so those are some tough issues. So let's say a product design change is made that makes the product better, but also harms a competitor. Generally, a court will say it makes it better, and that's enough. But then you get some tough issues. What if it makes it 1% better, but harms the competitor a ton? Again, there's going to be a lot of deference in the courts. And so that's probably where they would come out.
So I want to make sure that I respect Pam's respect for time as well. And so we are now at 2:20, which means that our panel is over. I want to thank all of our panelists. Thank you very much. It's very, it was great to hear from all of you. And I want to pass the baton over to the conference organizers.
Thank you all. Thank you all so much for attending. We will be taking another short break now, and we will reconvene at 11:30 for our next panel, Consumer Protection Issues. Thank you.